Okay, I think we're going to start, so we can have some time also for discussion and not run over. I understand that it's quite a difficult program with no coffee breaks or anything, just from one big subject to another, but there'll be lunch soon after this session. Okay, the topic of this first parallel panel is, as you can read, Nothing to Hide, Privacy and Surveillance in Europe. And I would start by just putting this within the overall theme of this conference, building a people's Europe, which, if anything, is even more salient today than it was a year ago when the theme was decided upon. A people's Europe. That means a Europe that protects the rights and interests of Europeans, those in Europe and even those outside it. A European way of life, almost, that seems to be becoming a new narrative for the European Union. Part of that is certainly core legal rights to human dignity, to privacy, and to safety and security. They are part of the European tradition even before the EU was created and have been fostered in national constitutions, in some national constitutions, and by national constitutional courts in a manner that is globally distinctive. Part of the EU panorama is important legislation adopted by the EU itself, and I only need mention the General Data Protection Regulation adopted last year, which of course was debated for a very long time before adoption. But part of the panorama is also important cases by supranational courts in Luxembourg and in Strasbourg that challenge state national security practices and the practices of global internet intermediaries. These cases are brought in large part by normal or relatively normal citizens. They are very activist ones. You think of Max Schrems, the Austrian law student, or non-governmental organizations such as national non-governmental organizations such as Digital Rights Ireland. But there are also some unlikely champions that end up before the European Court of Justice, and one of them is David Davis, the current Minister for Brexit, who actually, apparently, according to the leaked version of the infamous dinner, boasted not once but 3 times of the case that he successfully brought to the European Court of Justice and won against Theresa May as Home Secretary. Not very diplomatic, probably, in terms of his own future. But at the same time, we have not just a people's Europe, but also what I would term the onward march of a Europe of law enforcement. And this also, at the same time, seems unstoppable. We have the creation and the reinforcement of existing agencies, but also the creation of new ones. We have new and interlinking databases. The principle of interoperability is being applied across the board, allowing national police and border officials to access data directly, irrespective of the function for which it was submitted. Obviously, the question who supervises is an incredibly important one, and we will hear something of that, I suspect, this morning. But I would just point out that in this area, the role of citizens is also very difficult because of the systemic secrecy that applies in this area. On a positive note, Europe, and in particular the court cases and the legislation, has started a conversation, even a global conversation, not just with important third country states, such as the United States, but also with powerful private actors, such as Google and Facebook. A part that we didn't envisage at the time that this panel was devised was, of course, the role that the UK will play in all of this. But I think that is definitely part of the panorama, and it is something that can be addressed in the questions, because obviously the fact here is the UK actually drove a lot of the developments in the security field within the European Union, and it has also opted back into key measures, Europol, Schengen Information System, PNR, etc., very recently, and judged it after an exhaustive process as being in its own vital national interest. So this is also a space to be closely watched, to put it mildly. So it gives me great pleasure to introduce, I think we have a fascinating panel here this morning to address these issues. And we will first hear from Michael O'Flaherty, who's Director of the EU Agency for Fundamental Rights. That will be followed by Bruno Giancarelli, who is head of the International Data Flows and Protection Unit within the European Commission. So we will get more of a policy view, and someone who has actively participated also in international negotiations in this particular area. Fernanda Nicola is visiting the Department of Law at the EUI as a Ferdinand Braudel this year, and she is Professor of Law at the Washington College of Law, American University, obviously with an outside US view. And Francesca Galli, who is an expert on criminal law and police cooperation and is associated with the University of Maastricht. So, Michael, I'd like you to give your comments. Thank you. And the speakers, again, will speak for a maximum of 10 minutes, and then we will go into discussion mode.
Deirdre, thank you very much indeed. I'm very grateful to be here, but I'm also grateful to you, Deirdre, for framing this panel and locating our focus on issues of surveillance around the place, the status of citizens within the European Union. Of course, I wouldn't be a human rights lawyer if I didn't express some concern with an overuse of the word citizen, because not everybody in our territories is a citizen, and we are, of course, talking about people within our societies. But that point made, let me move to the panel's topic. The introductory text for the panel frames things quite loosely and invites us to speak to all manner of surveillance, be it public or private. But for our purposes this morning, I'll focus on state surveillance issues. And in focusing on them, I'd like to add to some of the framing elements that we've heard just now from Deirdre by adding a few of my own. The first is a perfectly obvious one, that we're living in societies that are nervous and are preoccupied with strengthening their national security systems. Secondly, we're having that experience in a context of a vastly expanded range of data sources, exponentially different to even a decade ago. Closely related to that is the extent to which these data sources are becoming available and access to them is becoming possible through very rapidly evolving technologies. I found in this and in any other digital context that I should just admit defeat. I'm not going to understand, because no sooner will I understand today than it will have changed again in terms of the speed of the technologies. Closely related to that is the extent to which, even if I'm focusing on national security and state surveillance, we can't avoid the complex interplay of the public-private. The state could not do what it chooses to do without the participation of the private sector and so forth. And then finally, and this within the narrow context of surveillance, very distinct issues arise depending on the forms of surveillance at issue. Let me just mention one fundamental category distinction, that of targeted and untargeted surveillance, which raises issues both of technology, of law, and of course of policy. But before getting into that stuff, there is something else from the introductory note that I want to engage, and that is the extent to which it invited us to say, if we so wish, that we don't care. that the trade-off between, we don't need to worry about the loss of privacy. We either don't care or we just have to give up. So I think the first question we have to answer for this panel to be meaningful is, do we care? Now, I don't know the answer, quite frankly. I care, but I have no idea if that represents the general view of people in the European Union. Curiously, we will know next year. My agency will roll out the largest ever survey of attitudes to human rights that's ever been attempted across the EU member states. And we will be asking smart questions on attitudes to such human rights as privacy. So we'll actually have a bit of empirical evidence sometime in the next 12 months. But you know, already today, not knowing the answer, let me just say that if we don't care about losing our rights, then we really have a serious problem. If we don't care about losing our rights, that's a subset of this general sense of a lack of confidence in the human rights framework that's been built up so carefully in Europe and elsewhere since the Second World War. And that's something that worries me greatly, and it preoccupies our agency, and it's a matter that requires high attention in Europe, because if we carelessly let go of the human rights standards and values that we've embedded in our societies and in our state structures, then we run a risk of unraveling the piece that has been so carefully put together. But let me turn now to some of the legal issues. And of course, international and European human rights law is pretty clear. That the law recognizes the need for national security, that's not at issue, for strong public security, and at the same time recognizes such rights as privacy rights. And by the way, just in passing, let's say that to the extent it recognizes a national security requirement and the need to protect human rights, it recognizes it as much in the digital as in the non-digital space. It's the same law, whether we're online or the state is online or tapping a telephone. Now, for this correlation of the need for national security and the respect for rights, we have to recognize that those human rights are almost never absolute. Very few of them, as you know, are absolute. And privacy is not an absolute human right. It can be restricted. The key, though, the trick, is delivering the restriction on that right in the legitimate interest of national security, subject to some very strict rules. And I'll just name them. Have no fear, I'm not going to go into them in any detail. But the basic principles of legality, necessity, proportionality, and non-discrimination. They, for me, are the four buzzwords. To limit any right, including the privacy right, in the interest of national security, the state must demonstrate that its actions are legal, that they meet a requirement of necessity, there was no other way to achieve the good, that they're proportionate, and that they don't engage in the forms of discrimination that are prohibited under the international human rights treaties. Now, that legal base is how we frame our work at the Fundamental Rights Agency. And let me turn for my concluding remarks to some of the ongoing work of the agency precisely in this area. A couple of years ago, we were invited by the European Parliament to do an assessment from a human rights point of view of the surveillance frameworks adopted by each of the 28 EU member states. We published the first part of that material already last year. Let me just give you a little flavour of some of the findings, having closely reviewed the 28 legal frameworks across the EU. In the first place, we saw, and it'll come as no surprise to those of you in the area, that there is no agreed national security definition. We have 28, or more or less. And the understanding of national security varies enormously from state to state. And that vast differential is problematic in terms of a consistent respect for rights. Second, and this was really remarkable, we found law for untargeted, for so-called signals intelligence in only 5 of the 28 member states. And you could argue here that for the other 23 states, they're already violating the principle of legality in terms of signals intelligence as opposed to targeted surveillance. Third, we identified a really worrying unevenness in the effectiveness of oversight systems across the member states. They vary hugely, and many of them are confronted by very important challenges of capacity, of access, of expertise, of resources, and all manner of other issues of that kind. And fourth, big issues with regard to access to remedies. It's very difficult to get your day in court if your rights are violated in the surveillance context. And by the way, within that context, data protection supervisors have been given very limited roles with regard to this area. Now, the second phase of this work on surveillance will be rolled out this year, in a few months' time. I won't share with you the findings today, but let me tell you already, by the way, this second phase was asking practitioners, people working in the surveillance systems, in the oversight bodies, asking them about how the frameworks work in practice. And we got a lot of answers, rather worrying. Firstly, the practitioners themselves tell us that the laws are too vague. They tell us that they're working with definitions that are too loose. They speak of the obscure structure of the legislation they work with. They mention a lack of transparency. These are the practitioners themselves saying that they would like to see more transparency in how they do their work. And finally, they worried about the limited levels of expertise for the undertaking of surveillance in the context of the high complexity of the technology today. Now, let me briefly turn to one other study which is ongoing, and that is our study of the biometric data gathering at Europe's borders, particularly in the context of migration and the issues of the interoperability of the databases that guard such information. The first thing here, we've identified a problem with the entry of data. Half of our interviewees, the professionals who run the systems, tell us that mistakes happen. And if a mistake happens at entry into the databases, well, you can imagine all manner of bad stuff that can happen following on from there. And then, since I've been given the 1-minute warning, just one issue on interoperability. There are many issues to be paid close attention to on interoperability, but one is with regard to the purpose for which the data was collected. We could easily slip into a situation where data gathered for one purpose is used by the state or states for another purpose, including for purposes of surveillance. And that would be problematic from a human rights point of view, and it requires close attention with the upcoming legislation that I guess Bruno will speak to. And by the way, I don't sense any challenge to us in bringing this point to the table in the interoperability discussions, but it will need close attention. So I'm going to end up there. Let me just say that I don't like a discussion of national security and human rights as a kind of a zero-sum discussion, where you either have human rights or you have national security. I don't think it works like that. But it does require extraordinarily close attention to figure out on an applied day-to-day working basis what honouring the human rights standards requires in terms of how the security frameworks are crafted. That's in large part the business of my agency, but this is an academic institution, and many of you are academics, I assume. And so could I plead with you to work more closely with us to figure out these answers, to show that you can both have strong national security and a high degree of human rights compliance in our societies. Thank you.
Thank you very much, Michael, for setting out the challenges that face us also in extremely fundamental and precise terms, and for bringing in the empirical element as well. That's fascinating. Bruno, I'll hand over to you for a view within the Commission, but also looking outwards to third countries.
Thank you very much. I'm delighted to be here. Real pleasure and great privilege. I've been asked indeed to focus my presentation on the EU-US privacy shield. As a concrete example, some will say an attempt to square the circle, to address the relationship between privacy and national security. You probably all know this, but it might be worth recalling what the Privacy Shield is. It's a framework that has been put in place for the transfer of data between the EU and the US for commercial reasons. It is a framework which is not an agreement in the formal sense, because it is applied through what is called an adequacy decision by the Commission, and that adequacy decision has been adopted last year. And what's an adequacy decision? It's a finding by which the Commission considered that a foreign system, in this case not the entire US system, but a specific scheme, regime, framework put in place by the US, that foreign system offers an adequate level of protection, and that therefore personal data can be freely transferred without any additional conditions between the EU and that foreign system. That's one of the ways in which our legislation, both the current legislation and the new one, foresees as a tool for transfer. And this decision on the privacy shield is particularly relevant for the discussion we are having here for a number of reasons. First of all, from a legal point of view. You've mentioned how our Court of Justice have been active in Luxembourg, in Strasbourg, at national level. This is the first adequacy decision that was adopted by the Commission following the Schrems ruling, which had precisely quashed, annulled a previous arrangement called the safe harbor, precisely because of its lack of reasoning of findings concerning governmental access. What the court told the Commission with that Schrems ruling is basically, when you are assessing the adequacy of a foreign system, you need to carry out a comprehensive assessment, which does not only look at the privacy law stricto sensu, but also assesses the conditions, the limitations, the safeguards, including appropriate redress and remedies mechanism, the conditions, the limitations, the safeguards, under which once the data is transferred, it can be accessed by public authorities in the foreign system, including for national security reasons. This decision, the Privacy Shield adequacy decision, is also relevant to our discussion from a more factual point of view, I would say, because it concerns transatlantic data flows to the US. And the US, our country, is a country that uniquely combines the presence of the champions of the digital economy, the Google, the Facebook of this world, together with the most developed, the most extended surveillance capabilities in the world. This is important not only because it means that for one reason or another, large volume of data go to or through the US, but also because it reveals how today, more than ever before, considerations relating to the privacy of individuals, to trade, which increasingly relies on data flows, and to national security are linked, intertwined, to a degree that one could have hardly imagined only a few years ago. Even the dividing line between these concepts and these considerations are not always easy to draw. In many routine situations, personal data may be transferred for purposes that have nothing to do with national security, commercial or even personal communication reasons, and may then be subsequently, sometimes even large volumes, accessed by national intelligence agencies. And the technology development that you already mentioned have greatly facilitated this type of collection and access, and thus further blurred the limits between these various concepts. So this is certainly part of the problem we are discussing today, but it may also be part of the solution. And I think the privacy shield shows it, as this interaction, these links, create new reasons, new incentives, because the digital economy needs the confidence of its users, new incentives to address and possibly solve some, at least, of these issues. Issues that previously were much less central and thus much less visible and thus much less relevant in this context. So how did we address these issues in the Privacy Shield negotiation and the Commission decision resulting from this negotiation? Needless to say, this was not an easy discussion, was not a walk in the park. The US side was initially very reluctant to be drawn into a debate on national security in the context of a framework that was essentially a commercial transaction framework. At the same time, the Commission faces a treaty limitation on its competence for national security matters, and at member state level, and that has also been mentioned, we see a quite lively debate as to how to balance national security and with privacy issues. Member states were probably also in a quite paradoxical position. They wanted the Commission to reach a deal, find an agreement, because the previous arrangement had been quashed, while at the same time they were probably slightly worried that in doing so the Commission could come too close to matters of national security that they consider as part of their domain réservé. On the other side of the spectrum, we have important institutional actors, such as the European Parliament, our national data protection authorities, which had and have high expectation and pressing demands on these same issues. Moving now very quickly to the substance of our work, assessing from a privacy, from a fundamental right point of view, the rules on national security access, in particular the rules of a foreign system, raises a number of complex issues. First, you have to identify the relevant rules. Apart from the issue whether they are classified or some might be classified, but they are generally dispersed, spread in many different texts, statutes, regulation, administrative rules, case law, etc. And we know how clarity and accessibility of the rules is essential from a fundamental rights point of view. Second, you need to get an understanding of how these legal rules operate, are applied. Third, this type of assessment requires to assess these rules against the EU law criteria, especially the one laid down by the court in Schrems, essentially whether the standards of strict necessity and proportionality of the interference with the right to privacy and data protection. Finally, if necessary, you need to deal with possible shortcoming and you might need to fill the gap of that system. So you can find in the Privacy Shield framework, these various elements are reflected in the Privacy Shield framework, and I have no time to go into the details. Let me only mention very briefly the nature and the structure of the framework, which is no longer based solely on obligation undertaken by private entities, but also and for the first time on representation commitments made by US authorities, in particular on condition, limitation, and safeguards applying to government access. And you have interesting elements coming essentially from the surveillance reform introduced by the previous administration on how certain concepts like targeting and tailoring of collection, while not identical to the principle of necessity and proportionality, may actually capture the essence of this principle. Another interesting element, talking about citizens, is the introduction of a new redress, remedy mechanism. That's a particular important aspect, and that's a particular difficult aspect in this context. And as many of you may know, we have pushed and obtained the creation of a new redress mechanism through the Privacy Ombudsperson, which is a body independent from the US intelligence community, and which is competent for handling and resolving complaints by EU individuals on national security access. From an individual rights perspective, this is a significant development, as at international level so far, these issues are either not dealt at all, or if they are, this is strictly in a government-to-government context. I would like to conclude by making one very quick observation and then mentioning even quicker a potential interesting development. A quick observation, a lot has already been said, will be said about whether the Privacy Shield is strong enough, is solid enough, there's litigation pending on court, etc. But what is often overlooked about this framework is that this is not a static decision, but it's a living document, it's a living framework that has some built-in dynamic elements. It's subject to an annual review, which will take place in September. It provides for a number of redress mechanisms that can be activated by EU individuals. It requires the EU and the US to cooperate and inform each other of relevant developments. In other words, in particular, when it comes to aspects relating to government access, to government surveillance, we, so to say, got our foot in the door, but this is not the end of our work, but rather the beginning of a process which is, as any dynamic process, can develop over years and bring about new developments. At the same time, the Privacy Shield is very dependent on the legislative and regulatory environment, the ecosystem in which it was created, because it builds on certain reforms which then have been developed in that particular framework. So it is essential, and that's a message that the EU is very clearly channeling to the new administration, it is essential that the foundation on which it is based, you've mentioned signal intelligence, a very important reform of the previous administration was introduced by the so-called Presidential Policy Directive 28. It is essential that foundations such as this document remain in place. Very last observation and wish, there is a clear and increasing need in this area, demand for international standards. Not sure that governments are ready for that, but there are processes which are developing and which could be interesting. I'm referring to national oversight authorities talking to each other, working together, and why not developing some standards. The FRA has organized some meetings. They are also organized by some forum by the UN Special Rapporteur on the right to privacy, and we see other developments. Thank you very much for your attention. I have already abused of my time. Thank you very much for your attention.
Thank you very much, Mr. Giancarelli, for this fascinating account and very clear. It's a very complex document, the Privacy Shield. It's also a living document in the sense that its legality is also, I believe, under challenge at the court presently. So we shall see how that develops, but we're not going to go into that now. I turn to Fernanda Nicola, who will give a view from probably the US.
Yes. Thank you very much, Deirdre, for this panel. And I'd like to talk about start from the Schrems case that many of us already mentioned, that invalidated in October 2015 the basically safe harbor provision for the transfer of data transatlantically between the US and the European Union. What I want to focus on is to think about courts, and in particular in this case the European Court of Justice, as not only actors that will protect individual rights in the case of data privacy, but also as engines for change, engines for policy reforms, and also collaborating with agencies such as the Commission or agencies in the US, from the NSA, the National Surveillance Authority, to the Federal Trade Commission and the Federal Communication Commissions that all together basically deal with the issue of data privacy on the other side of the Atlantic. The Schrems decision had, as I said, not only an important impact to reinstate the fundamental commitment of the European Court of Justice in protecting an individual rights that under the European Charter of Fundamental Rights is the right not only of privacy of an individual in Article 7, but also in Article 8, a right to data privacy. So part of you, when you transfer that data, is taken away, is collected, and you ought to give your consent because that's still part of an individual that we know from the right to be forgotten. The Court of Justice is developing a very influential jurisprudence that has global effects. So last week in Washington, D.C., Bruno and I were both attending the meeting. Every 3 years, the European Court of Justice meets its U.S. counterparts, the U.S. Supreme Court. And in these meetings, data privacy, the Schrems case, were really at the forefront and were compared to the U.S. Supreme Court activities in this area. Justice von Danowitz, the German judge who was the judge rapporteur of both the Schrems case and the digital rights case, talked in a very impressive way about what was really the outcome of the Schrems decision, what the court did. And as I said before, it did the two things. On the one hand, establish how do we protect this fundamental right to privacy, and how Director O'Flaherty explained, this is of course not a fundamental right that cannot be limited, but certainly there are limitations only if strictly necessary, as the court explained, with not on an automatic, basically, not automatic authority for the government to limit that privacy without a necessary, proportional, legitimate expectation that has to be shown by the government. So no generalized access to content or communication data. There have to be justifications, and the only fact of a terrorist threat cannot be sufficient justification for such limitation. There needs to be also a possibility to assess legal remedies in order to limit their fundamental rights. And as the Schrems decision explained, that in the recognizing third countries' protection of data transfer and data privacy, there must be essentially equivalent means that can be different in various countries. This led, as Bruno explained, to the agreement between the EU and the US on the privacy shield. And this agreement is again being challenged, and we'll see where this will go. What's happening in the meanwhile on the other front, meaning the US front, is also a bit of agency turmoil under the various executive orders of President Trump, and also the reallocation of competences on who should handle data privacy. And I will go right now on these developments, but let me say that Justice von Danowitz's intervention last week in Washington concluded with 4, I think, important points. And I want to start from those to then show you what's happening in the US. On the one hand, he explained that it would be fantastic if we could agree that there is a right to privacy that should apply to all individuals irrespective of citizenship or residency. And I think that's a very ambitious request, not so ambitious for us as Europeans living in member states in which constitutional orders have recognized a right to privacy, but also at the EU level we have this very strong privacy protection. The US counterpart is very different. Privacy rights are shadow rights. They're really encroaching upon other freedoms, such as freedom of expression, democratic freedoms that go from secret ballots to freedom to intimidation, and finally they encroach on issues of culture, sport, music with censorship. There's not, the shadow rights of privacy have led to a very non-existent litigations for private individuals in these realms, especially vis-a-vis, for instance, national security claims, and that was the concern of many panelists for the fact that privacy rights are shadow rights that are protected in the US under either First Amendment protections for limiting free speech or limiting rights of associations, or under Fourth Amendment protection, meaning the prohibition of unreasonable search and seizures. This is the realm, Fourth Amendment protections in criminal, basically in criminal cases. This is the realm in which privacy protections are developing the furthest. And actually we have some very important decision, United States versus John, for instance, where Scalia decisions that says basically there is an unwarranted search in this case when there is a GPS attached to the car of a drug dealer. The drug dealer is going around Washington, D.C. He's being basically targeted throughout for going to the hairdresser, but also for doing drug dealing things. And basically this goes too far. And there is a decision of the Supreme Court with Scalia, who writes the majority, but also a concurrence by Justice Sotomayor that says awareness that government might be watching chills associational and expression freedoms. and the government's unrestrained power to assemble data that reveal private aspects of identity is susceptible to abuse. So the same concern that were expressed here are expressed in Sotomayor's concurrence, and what we have, though, is a very different context. We don't have here a direct protection of the right to privacy. We have here a fear that in criminal cases the government might overreach, and right now we have a pending cert of a very interesting case, which is called Carpenter versus United States, in which the warrantless seizure and search of historical cell phone records revealing the locations and movement of cell phone users over the course of 127 days is permitted by the Fourth Amendment. And so the question is whether the Fourth Amendment can be used as a stronger protector of privacy rights, as opposed to what actually cell phone companies have been talked about, like as a third-party rule. This third-party rule allows broadband providers to basically acquire information. Once you use the broadband provider to circulate your information, you basically withdraw your right to privacy. And this is huge if the Supreme Court is going to take this case. So on the one hand, you have the advocacy side. On the other hand, you have the agency side. And what's happening in the US, it's, there was a joint statement March 1st by the chairman of the FTC, the Federal Trade Commission, and the chairman of the FCC, the Federal Communication Commission, and together they said that they are committed on the online privacy of American consumers, but they believe that the best way to do that is through a comprehensive and consistent framework. Americans, after all, care about the overall privacy of their information when they use the internet, and they shouldn't have to be lawyers or engineers to figure out if their information is protected differently depending on which part of the internet holds it. So what they're trying to do here, which is not completely clear if you're not an insider of the agencies in Washington, it's to take away the power of the FCC to regulate broadband and limits their access and collection of data, to shift the whole realm to the FTC. And if the legislation that has been already introduced in Congress by these two agencies will pass, that will mean that broadband providers, your AT&T, T-Mobile, etc., can collect all this info and sell it to advertisers without consumer knowledge. So this is a huge shift that is going to affect, I think, also the way the Commission, the Court, will review the Privacy Shield. Just to finish on von Danowitz's proposals was, why don't we propose a regime of remedies that should be global? And so he was mentioning the 2016 Judicial Redress Act of the Obama administration and initiatives of that sort. There should be global remedies for this sort of initiative, but even more utopian, he was proposing a global regime of independent authorities working independently almost from government, figuring out exactly what we were talking about before, how practitioners could find better rules and more clarity to regulate privacy rights of consumers. So on this utopian note, I think he had a point. He also found very prolific and productive talking to academics and agencies, representatives, but mostly practitioners and professors that could come to an agreement and show that this transatlantic divide could be bridged if government interests are somehow tamed and there's a real commitment to certain fundamental principles such as privacy. Thank you.
Thank you very much, Fernanda. I think there's lots of food for thought and for questioning and debate afterwards on that. But first, Francesca, you now have the floor.
Thank you, and thank you, Deirdre, for this kind invite. I'm also honored to be here as a speaker. Well, nothing to hide. Well, the relationship between privacy and the need to enhance security has certainly been always challenging. And I think that no matter why, we've been talking about the issue very many times and for very long now, but it is still topical because we have not managed to find a long-standing solution. And it is doubtful, in my view, whether actually the Union would be able to find such a solution, since in the end, national security remains in the realm of member states' competence. And what I would like to discuss in the available time is, first of all, the crucial changes in EU criminal justice, which I think have made the relationship between privacy and security even more complex today. And then the advances, or maybe failed advances, in EU data protection law involving different actors which have attempted to find a new trade-off. Well, let me start with EU criminal justice. There are 5 major changes. Firstly, we can see that terrorist attacks have been a catalyst for a change in surveillance practice. So surveillance practice becoming preemptive and generalized. Security governance will be focused on risk assessment rather than solely on the data revolving around a specific criminal offense. In that context, and that will be the second major change, the means at the disposal of intelligence agencies and law enforcement authorities have evolved in such a way that the share of competences and tasks between the two has become blurred. So the shift towards prevention in the fight against serious crime, including terrorism, and particularly terrorism, attributes a greater role to ductile and secret means of investigation that revolve around intelligence, rather than traditional means of investigation, which would happen under judicial scrutiny. Thirdly, given the development of anticipative or proactive criminal investigation, another fundamental change is an increase in the use of surveillance technologies. And that happens in relation to very many different offenses, not only in relation to serious crime, and at different phases of the procedure. So not only during the investigation, where they would happen, once again, under judicial scrutiny, but also during the phase of prevention. As my co-panelists have also mentioned already, what is also interesting here is that states are increasingly imposing on the private sector a number of duties, which is leading to a growing privatization of surveillance. And the cooperation between public entities and private entities is, of course, not new, but the fact that individuals share, in particular online, more and more data, and the fact that we have a growing amount of possibilities to gather and retain such data make the issue even more problematic. And finally, we have recent developments in EU internal and external security policy, and these have witnessed an increased relevance of information sharing in the area of freedom, security, and justice. So that reinforced police and judicial cooperation actually is carried out in great part by sharing and exchanging personal data. As a result, the scope of the databases that already exist is enlarged, and more actors have access to databases that were originally very often established for a different purpose, and very often not a criminal justice purpose. All these 5 major changes actually witnessed an increased attention to security and surveillance to the detriment of the right to privacy. And notwithstanding the fact that there is a rising importance of data protection in the EU legal order, the rise of terrorist attacks has led to a reconsideration of the value of data protection when the security of the EU citizens is at stake. And as this perception that our security is at stake is almost always there now, the limitation of privacy is happening almost all the time. Let me now move to the second part, so these advances or failed advances in EU data protection law. Over the last few years, we have seen greater awareness for surveillance practices into the public eye. But it is assumed that citizens are ready to trade off part of their privacy in order to have enhanced security. And that happens in different settings, and that actually has informed public policy, legislative developments, and also different best practices guidelines concerning security across the EU. Yet, we have two different contradictory trends. On the one side, governments have a tendency to increase the protection of personally identifiable information in the commercial area, and at the same time, the access and use of this very same information by law enforcement authorities is made easier. And despite the outrage that the very recent scandals that have occurred over the last few years have sparked all over Europe, there is the new trend in very many member states is to adopt this very same American mass surveillance approach that has been demised very many times, at least when we discuss it. In this context, as we all know, the Court of Justice has intervened. The court, in its case law, has set a number of requirements for the EU legislator to comply with when devising any provision which may clash with the right to privacy or the protection of personal data. And in a sort of interinstitutional dialogue, I think that the main message of this case is not that the rights to privacy and data protection are untouchable, which has been a bit of the refrain we have heard for quite a long time in some constituencies. They are not untouchable, but rather the message of these cases is for the EU legislator to take the lead to ensure that such rights are taken into account when devising a balanced regulatory framework. And how has the EU legislator behaved? Well, if we look at the data protection framework as it has been reformed and came into force in its new form after very many years of negotiation last spring, I think we can say that it clearly presents a number of deficiencies. And the main shortcoming is, of course, the fact that we have two different instruments. We have a regulation, which is valid for the commercial context, and a directive, which is for the law enforcement context. And that seems to be a bit of a step backwards with reference to what was envisaged by Article 16 of the TFEU that would potentially lead to a comprehensive instrument that would embrace different policy areas. And that is a weakness, of course, because the level of protection that is envisaged by the directive is de facto lower than the level of protection which would envisage or by the regulation. I see that you may not agree on that, but that would be interesting to discuss. And the resulting discrepancy could actually create a lack of consistency, which has serious practical consequences, especially because, as we have said, the data exchanges between public and private have been increasing. So that could be even more problematic. In the end, though, no matter how effective or ineffective the role of the EU legislator would be in clarifying the concepts and trying to establish minimum data protection standards all over Europe, I think that the role of the courts would remain crucial, not only at the EU level, but also at the national level. And that would be crucial because we need still to ensure that in concrete cases, the conflicting rights are each adequately protected. One final word to go back to Deirdre's introduction on the question of EU citizenship. Of course, this whole discussion is at the center of the discussion related to EU citizenship. Because, of course, EU citizenship enshrines a number of fundamental rights, including privacy and data protection. And the question here would be, is EU citizenship threatened by a global exchange of data? And I think it very much depends. It very much depends whether in its external dimension, the EU would be capable of imposing its balanced approach or its search for a balanced approach between privacy and data protection. Or, by contrast, if the Union chooses to lower its standards in a strategic mode, in a strategic view, in order to exchange data and fight serious crime in a supposedly better way, that could compromise some of the rights which are at the very core of EU citizenship. Thank you very much.
Thank you very much, Francesca, also for bringing it back to EU citizenship. But also to come to Michael's point, where you mentioned at the very beginning, I think it is indeed, I prefer the idea of a people's Europe, you know, the idea, particularly as EU citizenship is interpreted currently as being very much focused on those who exercise free movement. I think the attention, at least, is that we look at it in a broader context. But certainly in terms of the challenges, that's very clear. Now, I am 2 minutes ahead of when I'm supposed to open up to the floor, so I'm going to abuse my position as a chair and just very briefly put a few things on the table, and I will give all of you the possibility to respond to everything, also to one another at the end, and we'll do that in reverse order. But I'd just very briefly like to make a few comments myself. Michael, your point, do we care? I mean, I think this is also fundamental, and I think also the empirical work that I have seen that has been done on this in the US, I mean, it's great that your agency will be doing that in the future, is that people just feel defeated almost by the lack of control. They want to use certain things. In fact, they feel they need to, and then they often just click through whatever they need in order to get to it, you know, be it cookies or privacy policy or what to continue using WhatsApp or whatever. And you made another point, I think, that was very important. It's about the role of law in all of this, because law is, of course, always behind technology. And I mean, we can't have a law that will deal with the future either. But I think what we're seeing happening in Europe is that it is coming back to more first principles, and I think that was your point, that can apply to technology of different kinds. And I think that's what we, as lawyers anyway, should be striving towards. Your point on interoperability, I'll just make two more very brief points because I don't want to abuse my own time. I think, you know, most people switch off when they hear about the principle of interoperability as being something incomprehensible, technical, and whatever. But I actually think it's one of the most important principles out there in policy terms at the moment, because it describes how law enforcement agents of whatever kind at the national level, but also at the supranational level, can access the same data in various databases and then do something with it themselves without anybody knowing what is going on or without having any access. And as you said, I mean, the empirical work that you're doing is also incredibly important, just to show that mistakes are made, and we only know about certain things very rarely when actual mistakes are made. This is highly problematic. My last point, and I think this is one that may come back in the discussion, is global standards. This idea, you know, courts can only do so much. I mean, in fact, courts, they can, in my view, they sort of start a conversation, they are a trigger, and they force the legislator or the international negotiator to do something else. They've, in a sense, also private companies, intermediaries have to respond. So there definitely are responses, but a court can't solve it. A court at any level cannot solve it. So it's part of a conversation, a part of an ongoing, and I don't see an ultimate kind of remedy in that sense. I think even the risk with global regulation is, well, we have to look carefully who's adopting the global regulation, who are those, and how is that being discussed? Because it might just be sort of law enforcement, basically, who are doing that. So that's a question that I would have. I think certainly the idea of networking among authorities and all of that, fantastic. Anyway, I will stop here. So that's my points to the panel. We have a I have a number of people on my list. Okay, that's already 4. You will have to be brief, 5. Okay, Ricardo, it would be good if everybody introduces themselves just very briefly and keeps your questions short, because before I want to give the panel an opportunity to respond. And they can pick and choose, obviously.
Good morning, and thank you so much for your presentations and for being here with us today. I'm a first-year PhD researcher in law, and I just have a brief remark and 2 follow-up questions addressed to the entire panel. My PhD research falls on what we might call the next step precisely in the privatization of surveillance, directly important from the US. It has to do with the private-to-public incomprehensible interoperability required by the Passenger Name Records Directive approved in April last year. Basically, this is a counter-terrorism response of the European Parliament to the 2015 and 2016 terrorist attacks. And despite being rather unfamiliar to the general public, either caring or not, this new securitized trend seems, based on data flow, will have the extremely high cost of placing thousands or even millions of previously unsuspected travelers under secret surveillance every day. So under this framework, and following on your comments, my first question is, in your perspective, how are these preemptive surveillance mechanisms going to develop in the near future in the European Union, in particular, vis-à-vis the fundamental freedoms of movement for the citizens? And the second question would be, is this tilting towards security in the privacy security trade-off measurable in terms of efficiency and effectiveness in deterring terrorism and transnational crime within the EU? And if so, is it truly worth it to whatever we must give up on its behalf? Thank you.
Thank you, Ricardo. Well, I'll move straight on. I think I'm pretty much at the stage of closing the list. I have 5 people on it. Yeah, both of you. You wanted to have the floor? Yeah, Gunther. Right.
Yeah, does it work? Yeah, thank you. I'm Gunther Wilms. I'm the EUI's legal advisor and data protection officer after a career in the Commission. Hello? Microphone is not on? Hello? Yeah, I'm Gunther Wilms. I'm the legal advisor of the EUI and its data protection officer. Thank you to all the presenters for their clarity and Michael O'Flaherty for his frankness that he admits defeat. My question goes more to Bruno and links up to what Fernanda said about von Danwitz's intervention. In a recent meeting of data protection officers, they said that Privacy Shield is dead because of the executive order that basically limits the protection of privacy to residents and not to citizens, which has obviously an influence as well how we treat data transfer. Thank you.
Thank you, Gunther. You're next. Yeah.
Hi, I'm Gary Winslet, a postdoc here at the EUI. So all of you in one way or another mentioned sort of the nexus between public and private, and Bruno mentioned that a lot of the data travels back and forth between the EU and the US is also the home of some of the big internet champions like Facebook and Google. And so just generally speaking, how do you think about the relationship between these internet champions and government, especially the US government and your institutions? Thanks.
Thank you. Jorrit, maybe just behind.
Thank you very much. Jorrit Rijpma, Leiden Law School and ex-EUI. I had a question because I was very happy you mentioned it's not just about citizens' rights. If you now look at all the systems that are being built up, I'm thinking entry-exit systems, ETIAS, where there's a consistent criticism also coming from the EDPS, from data protection authorities. Are we then building a people's Europe by sort of closing off Europe and also making all these databases interoperable? And then I'm also wondering, are the institutions actually in the legislative process sensitive to this? Because I feel that consistently criticism is being made, especially, like I said, by the EDPS, and that seems almost to go unheard. It's almost a train that's unstoppable. So are we building a people's Europe by closing ourselves off and in the process perhaps violating privacy rights? Thank you.
Thank you, Jorrit. Jonathan, you have, and then I have one more person on my list, and then we go back to the panel.
My name is Jonathan Andrew. I'm a PhD researcher here at the EUI. Thank you very much to the panel for your presentations. My question is particularly directed to Michael and Francesca, as you spoke of the relationship between privacy and security. It would appear to me often when we speak of security, we think of very high-profile risks such as terrorism. But people in our communities face security risks every day. For an example, just last month I was in a town square and I saw a list containing the names of children, their dates of birth, and whether or not they'd be attending a public event. This was outside a school in a public place. I contacted the school, I contacted the National Data Protection Authority in France and said this was a concern. I didn't hear back from either. So my question to you is, do you think currently enough is being done to make public authorities, including law enforcement, aware of their responsibilities? And then do you think enough is being done on the enforcement side to make them accountable when there are breaches of data protection and privacy? Thank you.
Thank you, Jonathan. So the final question, Alfredo.
Thank you. Following the different presentation and your comments, I think global regulation by US or EU is still slower than technology. And the technology is going ahead for all this. And what can be done is following even the question of the person behind me, that global regulation made by US and EU can be imposed and eventually shared with the major, the internet champions, as I said, the big companies, because a top-down regulation probably is not the most successful idea. Thank you.
Thank you. Well, I think we have a lot of issues on the table for our four panelists. So I'll let you speak and obviously pick and choose in reverse order, and then we will sojourn. Francesca.
Okay. I think I would like to start with the first question you mentioned. Do we care? The problem with the question, do we care, is that not only, as somebody mentioned, there is no common definition of what national security is, but it's also no common definition nor perception of what privacy is. So if you look actually at the way in which you want to put the balance in different member states, the way in which privacy is cherished is very different. So we could say that, for example, in member states where we have experienced a past dictatorship, such as Italy or Germany, in Germany it's very, very clear also when they negotiate at the EU level, I think privacy has become, in a sense, something sacred that we don't want to be taken away. Whereas in other countries, the perception of whether privacy is at stake, it is not that sensitive. So that is, I think, it's a first problem. Or another issue, like in Italy or in France or in very many member states, we have our ID card. We can be asked our ID card in any different circumstances, whereas in other states, such in the UK, well, not a member state anymore, often, almost, but we don't even have such an ID card. So the relationship we have with our privacy and with personal data is different. So do we care? It's still something which is controversial at this very basic. The question that Ricardo had on the issue of PNR, What struggles me in relation to PNR is that at the beginning, at the beginning of the discussion on the issue, it seemed that PNR was something unacceptable and also, in a sense, quite useless. And then, at a certain point, there was a moment where we decided to make a UPNR because, well, it's not very useful maybe, but it's better to have an EU version which is not that bad than not having anything. So I think there we lost control of what the real question was in terms of the usefulness of that means that in my view actually leads just to a lot of racial profiling and is not even very useful in that term. So maybe we did a bit of a wrong understanding of what the problem there was about. And then in terms of do we manage to actually assess the efficiency or effectiveness of instruments? No, we don't. Again, it is an issue of perception, and in very many times when you come along with a new instrument in criminal justice, it's just for the government to give an idea to the public that something has been done. Not necessarily because that something that has been done follows a clear understanding of what the
Francesca, I have to interrupt. Yeah, I'm being told we have to finish very shortly, so I'd like to give the others briefly the word. Fernanda.
So I have 2 points. I'll try to. I have 2 points that might collect several of the questions. On the one hand, I'd like to just briefly address the issue of whether the privacy shield is dead because of Trump executive orders. And Julie Brill, who probably negotiated the privacy shield with Bruno, did explain that where the Privacy Act applies only to government databases, whereas the privacy shields cover corporate databases. So that would still apply despite the Trump executive order. And then no President executive order can override existing law written by Congress, and Congress hasn't adopted a law to that extent yet. And finally, the other mechanisms set up by the Privacy Shield, such as the Ombudsman that will look into requests from Europe about access to data by the U.S. government. Well, that Ombudsman is in State Department, which right now under the Trump administration, that Ombudsman role might have been reduced. But yet the Privacy Shield is still dead, and I think there's more chances that it's going to be reviewed by the Court of Justice and maybe struck down by the Court of Justice rather than the Trump administration in the short time. As to the other broader point, which I
just very briefly, because we really are running out of time.
Sorry.
Yep. No, just very briefly.
The other point is just about what Deirdre and I think Ricardo mentioned global standards for data protection and transfer data. And the point I want to make is that what we heard throughout is that practitioner or the market is very inclined to create these standards. So the International Conference of Data Protection and Privacy Commissioners is working on this. And so this is a classic case like immigration, when governments are becoming, they're limiting civil liberties, but businesses are favorable to immigration. I think we ought to study more the political economy of surveillance, data transfers flaws, because the political economy and actually the market community and the business community here is certainly more liberal and will push governments to act in a way to create these global standards that at this point in time are very welcome.
Bruno.
Very short, but I don't know where to start.
No, well, just choose.
Yeah, exactly. Well, first, then I will address the life or the death of the Privacy Shield. The Privacy Shield, let me be very clear from that, on that, is a framework which has been negotiated, has been adopted with the idea it is meant to last. And why I'm saying that? Because it has been negotiated on the just after the Schrems ruling, as I mentioned, and on the basis of the very requirements of the court, plus it have this dynamic, this review mechanism that is there precisely to avoid that issues become problems and are then solved before they become problems. I have to confirm, and I have also to maybe add something. There have been some initiative taken by the new administration, which probably don't signal a very positive attitude or good music, but they have nothing to do and they don't affect in any way the Privacy Shield. The executive order, simply because the executive order concerns in the field of immigration the 1974 Privacy Act, on which the Privacy Shield doesn't rely at all. So that's the beginning of an answer. I could be longer. But what that shows is that when you have, and we have the Privacy Shield, we have the Umbrella Agreement, which is a very other important achievement, when you are bound, when two important partners are bound by important agreements which bring them closer, all the pieces of the puzzle matter. When things like the executive order or other happen, it's very important that clarification, explanations come very quickly, because, as we can say, they can lead to a lot of misunderstanding. So a lot of else to say. I can just mention that on the point of effectiveness and efficiency that somebody mentioned, indeed, that's a very effective efficient collection. That's a very important point, and I believe it should be part of the test of necessity and proportionality.
Thank you very much. And now, Michael, you have the last word. The Irish are known for being brief under pressure.
Contrary to the Italians.
I'm interpreting that as a threat. 3 points, three brief points. The first, look, of course there's a tendency towards security responses. That's patently obvious. But it's in an institutional context of the EU with very strong fundamental rights, formal fundamental rights commitments. So what do? We insist on compliance with those fundamental rights commitments as a matter of law. But that's not enough. We can't just insist. We have to help show how. This stuff is so new that we stumble into violations very often. So we've got to do that job. I made the point earlier of helping the policymaker to see how to do it, and in this point also to show how the human rights respectful approach delivers better outcomes. It's not the contrary. Second point, yes, we have to maintain ongoing day-to-day dialogue with industry to try and keep up with the technology. But be careful. We shouldn't be asking industry to do the state's job. And there's a risk that we're asking the service providers, the platforms, to become the state's censors. And that raises issues of freedom of expression. And third and finally, privacy, yes, it's an underexplored right. It's little understood in practice. Curiously, in my experience, it's not that people aren't paying enough attention to privacy, but quite often they have an exaggerated understanding of what privacy requires. But general understanding does need to be raised, and that's why, by the way, I welcome the appointment of the United Nations Special Rapporteur on privacy. I think he'll go a long way in helping us unpack the content of this right.
Thank you very much, Michael. Thank you all, and now lunch. And the next session here is after lunch, the panel session by Dorothy Bola.